There was a pointed reason, and there were decisions that were made behind the scenes to include particular videos for their, for what they depicted in a, showing protesters in a negative light as opposed to the protesters in a positive light. It seemed that the majority of that compilation video included protesters in a negative light at the exclusion of the positive videos.
So the fourth week of the Tamara Lich and Chris Barber trial has come to a conclusion. The two co-defendants are being charged with crimes associated with their roles as organizers with the 2022 Freedom Convoy. The 2022 Freedom Convoy was a peaceful demonstration against what I regularly call the COVID-19 enterprise, this apparatus of control and surveillance and propaganda and censorship and mandates. All you out there in the audience, remember that. We're fortunate enough to be joined by Adam, who's a lawyer with the Democracy Fund. And Adam has been in the courtroom with us this fourth week. He's made his observations. He's got some professional pedigree expertise that he'll be able to share with us in terms of his legal insights. And we're going to show you that interview right now. If you want to stay up to date with our reporting and contribute to our work, please visit tamaratrial.com. I'm here with Adam from the Democracy Fund. He's a lawyer. He's got a professional pedigree that's relevant to what we're doing here in our reporting. Adam's been in the courtroom the entire week with the rest of us, and he's going to join us and be gracious enough to share some of his insights and observations with the rest of us laypersons. So let's go through chronologically, right? Day one, we had the judge decide that she would allow these Ottawa residents to testify, and you said something to me at the end of the last week over what the potential outcome of that, how that removes a sort of ground of appeal, just as a pragmatic outcome. Could you elaborate on that for the audience?
Sure. So basically, if because these witnesses were allowed to, and this is based on the fact that Justice Perkins McVeigh dismissed the application that was made by defense to have these witnesses excluded from giving testimony. So what defense essentially did was they made an admission under Section 655, which basically was that, generally speaking, there was mischief that occurred during the convoy. So Lawrence Greenspan's position was, okay, we've made this admission. We can obviate with the need to have these other witnesses, these 8 Crown civilian witnesses.
Obviate meaning render redundant.
Exactly.
Or relevant.
That's right. To render them irrelevant so that they don't have to save court time. He's already made this admission. We don't need to hear from them. So on Wednesday, Justice Perkins McVeigh stated that she's going to dismiss the application and allow these 8 witnesses to testify. So, on its face, it doesn't look great. Like it's like, if you're looking at that, it's like, oh no, from a defense perspective, that doesn't necessarily look like it's okay. Well, that's not for defense. True. But what does that do? What is the sort of long-term potential effect of that? Well, it sort of reduces the ability of the Crown to then later appeal on grounds that they were not able to, in a fulsome way, present their case the way they wanted to present it.
Yeah, the reason I'm asking this question is because I've received a lot of comments from Rebel News audience sort of asking whether or not this is a bad thing, that the judge allowed these witnesses to provide their testimonies, even though these testimonies were expected and, in my opinion, became largely irrelevant. But as Adam's explaining, if the judge would have denied these witnesses access to the stand to provide their testimonies, that would have been a potential ground upon which the prosecution at the end of the trial could have issued an appeal saying we weren't fairly allowed to present our case in the event that the judge would have rendered not guilty verdicts for the charges against the defendants. So that's a potential positive outcome. Now,
come on out November 25th. It's all aboard the Freedom Train in Niagara-on-the-Lake. You can check Rebel News for updates and also the Freedom Passport site.
Tamara Lich, who led the truckers' convoy, will be sharing the stage with some of the finest international recording artists, like the Chops Horns from New York City, who's played with Alicia Keys, Stevie Wonder, the Rolling Stones, and many more. Plus New World Sun, just off a European tour, and the legendary R&B master, Leroy Emanuel. Get on the Freedom Train with Tamara Lich. Saturday, November 25th at Niagara-on-the-Lake Central Community Center, 680 York Road. Get your tickets today at freedompassport.ca. The Freedom Train is coming. Know your rights. Know your freedoms.
The first witness that we saw this week was actually a witness that was called back to return from the very first week of the trial. It's an Ottawa Police Service officer, Constable Craig Barlow. Why is he important? He's sort of the digital cyber guy that works over at the OPS, and his job in the context of this trial was to go through video footage, mostly from body cam, video captured by police officers on the ground during the Freedom Convoy, and also aerial surveillance footage and even some video posted to social media online. And he created a video montage at the beginning that was part of the prosecution's sort of opening salvo, opening statement. And what we saw was defense attorneys sort of rebut that with their own excisions, their own video clips. Diane Magus was doing that, the defense attorney for Chris Barber. And whatever you might have recalled from seeing that, what do you think Magus was doing with showing her clips and asking the defense attorney, why didn't you include this? Or did you remember seeing that?
Right, exactly. Well, and that's what we saw. You know, it was Magus was putting videos that had been disclosed after the fact, because if we recall, the first introduction to Officer Barlow's video testimony was this compilation that you mentioned of videos that he we thought hand selected. We didn't at the time know why and in what format to make this compilation video. He was asked in cross-examination, you know, why did you not include this video, this portion of the video? Because it's since been disclosed. The full source videos have all now been disclosed. Defense counsel Magus asked him, why did you not disclose this portion and this portion? She puts a number of videos to him, and his answers to those questions sort of, you know, across the board unfailingly was that he wasn't asked to include those portions.
That's
right. So, you know, this portion that shows an individual protester, one of them I recall was a protester thanking officers for their service. Well, why didn't you include this? I wasn't asked. The other video that comes to mind was the infamous, you know, horses coming in and trampling seemingly trampling the one woman in the protest,
Yep.
and possibly others. Why didn't you include this video? Magus put to him. He answers, well, because I wasn't asked. And I think what what defense wants to establish there is that there is a narrative, as opposed to sort of, you know, justice being blind, you know, looking just to present the facts. I think Magus wanted to establish there that, look, there was a pointed reason, and there were decisions that were made behind the scenes to include particular videos for their, you know, for what they depicted in a, you know, showing protesters in a negative light as opposed to the protesters in a positive light. It seemed that the majority of that compilation video included protesters in a negative light at the exclusion of the positive videos.
Basically, the selection process behind which clips were included in that video compilation montage was of a sort of editorial slant to present a one-sided, as you put it, narrative, as opposed to a good faith, honest, sort of comprehensive depiction of the convoy itself. So the first witness that we saw that was an Ottawa resident that was invited as a sort of series or slate of witnesses who would then testify to harms they claim they suffered, they endured as a function of the Freedom Convoy, was this lady who lives right down here in downtown. You remember we were talking about her. She lived, floor 15 above the 10th floor. She worked not too far off. So why don't you share what you recall seeing from her in terms of what she said she endured and whether or not that was important at all?
Well, whether or not it was important at all, I mean, I think this is why Greenspan brought his application, you know, in the first place, is what exactly can any of these witnesses provide? What we saw from her was, you know, complaints about noise. You know, she could hear things hear honking in her above the 15th floor condo that she lives in. You know, what we didn't see was how this links directly to the elements of any of the offenses.
Right.
And I mean, and this is true for all of the witnesses we've seen this week. They have, you know, grievances. They are, you know, upset. We see that they're upset. We see that they've observed things that, you know, they say is, you know, made them uncomfortable. But we don't see anything concrete that directly connects to any of the dots from what I'm seeing of mischief, counseling mischief, obstruction, or counseling obstruction. So, we're in a position here where it's. I'm not really sure where the Crown is steering this and what exactly they hope to gain from having these witnesses provide testimony.
Now that I think about it, there's two things I remember about this lady. She said she felt scared. That's a quote. She said she didn't feel comfortable. That's a direct quote. Walking outside amid the Freedom Convoy. She also said that she wore a mask when she went outside for her walks and that she was jeered at or mocked. I think the type of person that would state or wear a mask outside in the winter tells you a lot about where that person is at in terms of what I call the COVID-19 enterprise. Now, one more thing about this lady. Greenspan asked her whether or not she was, as you put it, a party to this class action lawsuit against Lich, Barber, and some others. Why is that important?
Well, I mean, it's important because any testimony that they provide can be used in the civil suit. So that's why these questions are asked by defense. So Greenspan puts to them, hey, okay, have you been contacted or have you contacted Paul Champ and Associates? The answer, I think, for all of these witnesses has been unfailingly yes, save one. So that's 4 out of the 5 civilian Crown witnesses.
Quick interruption. Paul Champ and Associates, is that the law firm representing the plaintiffs in this class action lawsuit?
That's right. Yes, that's right. That's right. So there's an ongoing lawsuit. There are 15,000 unnamed plaintiffs. I believe there's 5 named plaintiffs. We're going to hear from Zexi Lee, I believe, on Monday. That's the intent. She's the next civilian witness. But getting back to your question, it's important because it potentially, the reason why defense wants to highlight this is it potentially shows a bias, right? Now these witnesses have an interest in the outcome of this case because it potentially could bolster the civil case that they are plaintiffs in.
A quick point here, correct me if I'm wrong, the value of the damages being sought by this class action lawsuit is $290 million, correct?
That's my understanding of it. Yes. So, I mean, it's obvious that defense wants to show, okay, look, these people, or the majority of these 8 civilian witnesses, are involved in something that is not this criminal trial, but is directly related to, and they could have a beneficial interest in something that isn't related to this trial, which would then they'd be able to then infer bias. If they show bias, it diminishes the credibility of the witness. And that's why you're seeing the Crown asking these questions.
Last point we'll close on. You mentioned disclosure issues. You mentioned this Jordan application, is that it? Or Jordan issue? Why don't you elaborate, explain to the audience what you mean?
Yeah, so what we saw at the end of the day today was that there's an issue with 400 pages, roughly speaking, of disclosure that defense has been made aware of, that they requested earlier this week from the Crown and have not yet received. Okay, so what does that do? Well, now the Crown has to provide the disclosure to defense. Defense has to have an opportunity to review this disclosure and then respond to it. What we understand is that this disclosure is relevant, well, from the defense perspective, but it is communications or an operational plan by PLT officers.
And PLT, just to be clear, that's police liaison
team.
That's
right. So the fact that this now exists, okay, and has not been provided has implications on the timeline of the trial. So, because like I said, if the Crown provides this disclosure to defense is going to need time. 400 pages, I mean, just to read 400 pages takes a ton of time. Then to scrutinize it appropriately so that you can cross-examine witnesses on it is another heap of time. So they're going to need this time to prepare adequately in order to have these PLT officers, which I assume are forthcoming as Crown witnesses. They don't have it yet. So now we're going to have to incorporate this into our future trial dates. Once this was brought up, and this was all brought up in housekeeping at the end of the day today. Once this was brought up, defense counsel for Chris Barber stood up, Ms. Magus, and she said, okay, well, depending on what happens here, we may have a Jordan issue. Jordan, generally speaking, is the 18-month ceiling by which the state or the Crown has to complete their trial. So Magus is concerned that this is going to go beyond that 18-month window And she's basically putting the Crown on notice and saying, okay, well, if you're going to continue taking your time and not providing us with this disclosure that we can't comment on its relevance because we haven't seen it, we are going to, should this go beyond that Jordan ceiling, that 18-month window, we are going to bring an application. Should that 18-month window be exceeded, the assumption is that the matter be tossed. I mean, it's pretty cut and dry. It's 18 months. Now, there's a caveat to that. None of the delay in that 18 months can be put on defense. So this also comes back to, you also have to do a bit of an analysis and see whether there was any waivers of delay by defense. So it's not clear cut. We're going to have to see how that plays out, but Magus has certainly put Crown on notice.
If you folks value and enjoy our reporting in the field, please understand that we have operational costs. We need your support. Please go to tamaratrial.com to help us and to stay up to date with our journalism.